of law, the foundation of a free and fair society where access to justice is available to all. It underpins our constitution and is what drives and unifies our 10,600 employees across 150 countries worldwide at LexisNexis. Enabling the way corporate, legal and government professionals do business, making it possible for them to shape the world we live in for a better future. A leading legal technology organization with more than 85 years experience in the South African legal landscape, we empower legal practitioners with access to the latest precedents, expert curated content and solutions to drive the wheels of justice in our country. Using artificial intelligence technologies such as data analytics, natural language processing and machine learning, we are reshaping the way legal professionals work. We offer governance, risk and compliance software solutions that assist corporate professionals in proactively identifying and managing areas that could potentially impact their business, and help human resource practitioners appoint the right people with the right qualifications to drive a profitable future. We play our part in making it possible for individuals to become the rightful owners of their first homes, bringing the property ecosystem together by harnessing the power of technology. We get it right so that our customers can get it right. We are advancing the practice of law, the compliance with law, and the upholding of the rule of law. Because at LexisNexis, we are advancing what's possible.
Good morning and a warm welcome to everyone here today. I'm Rudy Kruger. I'm the Corporate Sales Manager for LexisNexis South Africa. I've got some years experience in the banking services. I worked for one of the largest banks where we implemented compliance and screening solutions. I joined LexisNexis 14 years ago and had a pleasure to introduce our customers to enhanced due diligence solutions and screening solutions. As you saw now, LexisNexis is a legal and reg tech company, and we're the #1 player, tax, legal, accounting, and compliance solutions. Our sole purpose is to implement and advancing the rule of law, and we help our customers change their compliance obligations into opportunities. So LexisNexis is pleased to host this event, and such an important event as the FICA for legal practitioners, estate agents, and conveyancers. We want to welcome Yvonne Rossouw. She will be a speaker today. Yvonne will give us a quick overview of the Act, the understanding of why FICA is such an important process, and the requirements around FICA. So there is a Q&A block. Please add your comments there. We're going to try and answer your comments after the session of Yvonne. If you don't get time to answer all of it, we'll type up a document and send it to everyone. So I suppose we all ask ourselves why we're here today. So we're here to educate ourselves on the FICA requirements and process involved in FICA. And now we play a role in protecting our financial systems. Compliance is no longer a rubber stamp and saying we tick the box and on we move. So it is, how do we change our mindsets to be more involved and to take necessary steps to make sure that we implement the right process to prevent criminals from using us to launder their monies. Most crimes in the world is almost always linked to larger criminal syndicates and illicit activities, such as weapon trafficking, drug trafficking, human trafficking. Now, these criminal enterprises generate billions and billions of dollars every year in profits. And they need to use a gateway to get their dirty money clean. And they use us as accountable institutions to push that money through that system. So we need to implement processes to prevent this from happening going forward. So I want to give a quick introduction of Yvonne. So Yvonne is an accountant with 10 years experience in auditing and accounting profession. She has been part of the ProBeta team, facilitating auditing and probe courses, as well as legislative and tax courses. She's developed new courses and update material and legislative changes each year. She's also consults clients on compliance with FICA and POPI, as well as other legislative and accounting and auditing topics. Yvonne volunteers at various committees and working groups in URBA, FICA to provide input and guidance in developing of auditing and accounting professions. She has a passion for working with people and transfer knowledge she obtained to others for them to progress in their profession. We welcome Yvonne.
Thank you, Rudy, and very glad to be here today. Thank you very much for having me. I will now be sharing my screen that we're going to go through today. Just a bit of slides to talk to with regards to Poppy. Right, there we go. Great. So what I would like to take you through today is, why do we have the FICA Act? What's the importance of it? What is our responsibility? And then the one important part that we really want to focus on is our customer due diligence, or as you may know it, the KYC principles. Know your client. So let's talk a little bit about the purpose of the Act. Why do we have FICA legislation? I'm sure there's a lot of people who may feel that it's extra admin, it's extra work from our side. What is the point of this? What's the purpose? What's actually going on? And there is a good reason for it. It's not just that our government woke up one day and decided, oh, we are going to make it more difficult for companies to do business. It is actually, if you look at the purpose of the Act, it is to ensure good business, to ensure that we do better business, and to ensure that we protect ourselves. So unfortunately, globally, money laundering, fraud, white-collar crime, it is a pandemic, it is growing, and the enforcement agencies, not only in South Africa, worldwide, do not have the capacity to identify all the criminals, to find all the criminals, and to prosecute them. So they have enlisted the help of businesses, all businesses, to say that when you are doing business with clients, you want to make sure that you're not dealing with criminals. And if you identify the fact that you are dealing with criminals, we want that reported so that the enforcement agencies can take it further. And to be honest, that, like I said, just sounds like good business to me, because we don't want criminals to be our clients. We don't want to be in a situation where we are caught in a drug ring or human trafficking ring, and we were a company or a service provider that provided services or goods or whatever the case may be to those criminals. It's bad for our reputation. It's bad for, well, the financial system of a country. It's bad for the global economy. So there's really good reasons behind the Act itself. The Act does provide specific responsibilities for specific types of entities. So unfortunately, some entities have a higher risk of being used by criminals for money laundering, such as property conveyancers, and those entities are contained in Schedule 2 of the Act. There's a whole long list with over 20 type of entities. But for today's purposes, we're going to focus specifically on those involved in the property profession. So you can look at maybe your home loan providers is part of this process, your estate agents who will sell or rent property, and of course your attorneys who perform the conveyancing. And all three of those are included on this list of accountable institutions, meaning that all those entities that forms part of the property profession and a property transaction must comply with the FIC Act in its entire totality. What are those requirements that the FIC Act prescribes? Just quickly going through them. Number one, to be registered with the FIC Center, Financial Intelligence Center, so that they can identify who these entities are, and so that they can, of course, monitor to ensure that they comply with the legislation. Secondly, to develop a risk management and compliance program in which we will indicate what is the risk of our company, our entity being used for money laundering, and what controls will we implement over that. And then the important one for today, performing customer due diligence. That's the new term for it in terms of the change in the Act that came about in 2017. Before that, we knew it as KYC, know your client. A lot of people still it KYC. It means exactly the same thing. So whether you're talking about customer due diligence or KYC, please note it is the same. Then, of course, due to the fact that we have to perform these procedures to get to know our clients, we need to keep records of our clients, of their transactions, of the business relationships. And then the very important one, we need to report certain transactions, suspicious transactions, terrorist transactions, cash transactions. We're not going to talk about that in detail today. Then all employees that deal with the public, so an employee who's going to market a property to a client, help a client getting a home loan, deal with a client in terms of registering that property in their name, they all must be trained on the Act. The Act basically says that an employee cannot deal with a member of the public and provide this service if they haven't been trained, if they don't understand the Act. And lastly, all accountable institutions should appoint a compliance officer, which is the go-to person for any FIC-related issues. Inquiries from other employees, inquiries from the FIC center themselves. That's the person who will ensure compliance, who will ensure everything happens as it should in terms of the Act. Of course, if we do not comply with the Act, there may be quite high penalties. So the next thing I quickly want to talk about is just some statistics when it comes to conveyancing. And this isn't specifically money laundering through conveyancing. It is more statistics from the Legal Practitioners Fidelity Fund and Legal Practitioners Insurance Fund to indicate how many of their claims and how many of the issues they have is with regards to conveyancing. So this may include attorney fraud, fraud from an outside person, money laundering. So these are the claims they receive on conveyancing. Now, the last one I can find in an actual published report from the Legal Practitioners Insurance Fund, that's on the table on the right-hand side, conveyancing was only 18%. In the last meeting we had with them earlier this year, that has actually increased to 60%. So 60% of all the claims to the Fidelity Fund or then the insurance fund for legal practitioners deals with conveyancing, which shows that conveyancing is a high risk area for fraud. And well, where there's fraud, there's probably money laundering. Right. So this is just to indicate the risk that conveyancing itself does carry with regards to fraud and money laundering. On the left-hand side, those are the last published claims from the Fidelity Fund, and we can see conveyancing there was 40%. So also a lot more than all the other areas. So also very high risk with regards to probable fraud in this service provided by legal practitioners. With regards to non-compliances and actions taken against property practitioners, to be honest, I tried to get a lot of examples, but I couldn't really get a lot. There's a lot of action in recent times that have been taken against your banks, financial institutions, and motor vehicle dealers with regards to non-compliance with FICA. Not so much published action taken against property professionals. I'm not sure if that is because, well, maybe they're doing the right things or maybe they just haven't had a proper inspection cycle yet. But please just take note that there are quite high penalties and very negative consequences of non-compliance with the FIC Act. Let's start with the basic non-compliance and basic penalties that you may look at. Number one, non-compliance in terms of not knowing your client. So identifying who your client is, identifying the risk of them using you for money laundering or using a property transaction for money laundering. If you don't go through that process properly, you can get in a lot of trouble from the FIC Center. The penalties with regards to the FIC Act range between 50 million, that's 50 million, up to 100 million. So quite high penalties if you don't comply with the requirements of the FIC Act itself. Over and above that, of course, depending on the severity and the seriousness of the issue, you may lose your license to trade as a property professional. You may lose your license to trade as an attorney, as an estate agent. So that's really very stringent consequences that we want to avoid, that we want to ensure does not happen. So in the news quite recently, there was no specific outcome yet. Maybe some of you may have heard of it, maybe some of you won't. Pam Golding was investigated by the FIC Center, or probably still busy investigating them for the fact that they did not comply with specific KYC requirements for politically exposed persons. And we'll deal with that in a moment in terms of exactly what you have to do. So that's the first implication, is that you may not comply with the FIC Act in terms of knowing your client, in terms of reporting suspicious transactions, and then you may be penalized. The second specific instance of bad consequences, negative consequences, is if you yourself as a property professional actually commit fraud. So that's the second instance we have there, an attorney who was part of a bridging finance scam, who was fined 300,000 Rand or 3 years in jail. So there's definitive jail time for you as a property practitioner if you yourself are part of fraud or money laundering, if you are found guilty. And then the last, and this is a very, very important thing to note. If you are being used for money laundering, if you are being used by a scammer, you may not even be aware of this, and you can still be penalized quite harshly. This was a specific case where an attorney had a client for whom they did a range of transactions. They had money in the trust account for this client, and they received an email purportedly from this client stating that their banking details has changed. They didn't call the client, they didn't follow up, they just accepted this email about the change in banking details. They paid out certain amounts based on email instruction into this new banking account. And at the end of the day, the client lost 1.7 million Rand. When it went to court, the attorneys were found negligent in that they didn't perform proper KYC principles. They didn't follow up with their client in terms of, did the details really change? I mean, pick up the phone and call. And the attorneys were held liable for that 1.7 million. So you can be held liable for the losses of your clients if you are being scammed by a third party and you didn't perform the proper procedures as required by the FIC Act. So I think quite important to take note of those repercussions. Now, does that mean that the FIC Act is only bad news? Does that mean that it will only lead to penalties if we don't do what we should do, if we don't comply? And the answer is no. There is a very good benefit to the FIC Act in that it provides you with procedures to perform to ensure that this does not happen. So it provides you actually with a list of procedures to say, do the following. Know who your client is, get the following information, contact your client, follow up if there's changes so that you can avoid situations like these. So we're not saying at the end of the day that you as a property practitioner is necessarily responsible for identifying all criminals or for identifying all criminal activity or for avoiding all criminal activity. What we are saying is just implement controls. That's the important part. If you can prove that you have these controls implemented, that you did ask the right questions, that you did go about the procedures you were supposed to do, and still at the end of the day, it happened that you dealt with a criminal, but really you didn't know. There were no red flags, there were no indication. Then you should be fine. Right? Or if you follow these procedures, you may actually avoid an instance where you are paying money into the wrong account and losing money on behalf of your client that you may be held liable for. So that's the importance and the need for FICA. As I said, at the end of the day, it's about doing good business. And FICA enhances your ability to do good business by providing you with these specific procedures that you can then perform. Now, before we talk about the KYC in terms of the FIC Act, I quickly want to talk through a few examples of money laundering. I think it is important as property practitioners and property professionals, whether you are an estate agent, whether you are attorney, it is important that we are aware of how fraud can take place, how money laundering can take place with a property transaction, so that we can be on the lookout for these type of suspicious transactions and suspicious clients. There's no use just knowing the act requires you to do A, B, and C. If you don't understand how that is applicable to your day-to-day job, to the clients you may come in contact with, to your job that you are doing, then it's sometimes difficult to identify the red flags. This is a specific document that the FIC Center issued. You can get it on their website as well. They actually do this on a regular basis where they issue documents called case studies and typologies, where they discuss things that they have identified in practice, how certain sectors can be used for money laundering. And this specific one dealt with the property sector. Now, unfortunately, the property sector has many attributes that make it very attractive for illicit funds. But not that I'm saying that we make it easy in terms of property professionals because we're not asking the right questions. It's just the nature of the profession itself. Right? It provides a home in which offenders can live and work. It provides them with high value assets that they can use to turn around illicit funds. So it's really a host of mechanisms commonly used to frustrate and conceal the source of criminal funds doing or using property transactions. So looking at the specific examples they provided, the first one deals with concealing the ownership itself. So where a criminal, and I'm not saying all clients who do this are criminals. Of course, that's an important thing to note about the FIC Act. The FIC Act doesn't tell you that all clients are criminals. It just says that you have to be a little bit skeptic. If the client asks for certain things, if there are red flags, if something is unusual, just ask questions. Do a little bit of research, go a little bit further. So, as I said, concealing the ownership by using nominees and fronts. So, to facilitate the money laundering, the criminal will register the property and the bond or the bond in the name of a nominee, a relative, a friend, a business associate, another lawyer, a shell company, a front company, a fake company, whatever they can, because they want to distance themselves from the criminal funds in the first place. So that if any questions is asked later, it doesn't come back to them. It goes back to the person in whose name the property is registered. I mean, it's not unusual. It happens in a lot of normal instances where family members would like to register a property, maybe on the name of a child, a grandchild, for estate planning or for whatever the case may be. But that's why the FIC Act requires you to obtain knowledge of not only the person entering into this transaction, but also the person that they are doing it for. So if we are in a transaction where the person purchasing the property is different to the person on whose name the property will be registered, you have to perform the KYC principles for both. That's the important message to take away here. The second item on my slide, property related companies. So definitely criminal organizations can launder money through estate agencies, bond brokerage firms, construction companies. That's quite popular, especially because construction companies like to deal on a cash basis for tax purposes, which in and of itself isn't necessarily as above board as it should be, but it's easier in that way for criminal funds to exchange hands without anyone really knowing about it. So there was an example from the FIC Center there where the money launderer incorporated a number of shell companies and trust accounts through which these illicit proceeds were funneled to purchase a property, and it made it quite difficult to trace the funds. That can also make it difficult for you as a property professional, as the estate agent, as the attorney, when we ask that question, what's the source of the funds for this property transaction? Where does the money come from? Well, if it's coming from different companies or a group of company for whom you can't really identify the beneficial owner, sometimes that may indicate red flags. Sometimes that may indicate that there is something more going on here. Using bonds, right? So these are for the home loaners. So criminals, even though they have a lot of money lying around from their criminal exploits, may still use a bond to purchase a property because it seems more legit. There's less questions asked when you take out a bond to purchase a property than if you say, here's 3 million cash, let me purchase this property. However, after they have taken out that bond, they may start paying it off with lump sums. So more than just the monthly repayment, or more than their disclosed income would allow them to pay off. And that is then how they use their laundered money. Income property or investment property is another technique. So purchasing a property that they can rent out and then mixing their criminal revenue with the rental income. And that's something that estate agents specifically may need to look out for when they are doing rentals for large companies who purchase investment property for the specific reason to rent it out. There's nothing suspicious about that practice. I mean, it makes good business sense to invest in property that you can rent out. But in that instance, you want to make really sure when you do your KYC that the client you have, right, has their business is legit, it is proper. There's nothing untoward. There's no red flags. Do some research on their business, on what it is that they do, so that it makes sense that there are no perhaps criminal revenue mixed in here with the legitimate rental income. It's not always going to be an easy process, unfortunately. So that's why I said as long as you follow the principles within the Act and you've complied with the Act and you haven't identified any red flags, any issues, any problems, well, then no one can fault you. But if you haven't done anything and it comes out at the end of the day that this may be a criminal syndicate that's mixing their criminal revenue in with their legitimate rent, you may be in a situation where you can be found negligent. Flipping property, well, that of course means buying a property, renovating it. As I said, usually with the construction companies where they do it nicely in cash with their illegal proceeds and then selling it again. And selling that property, then it's just a sale of a property. So the return seems very, very legal in that instance. It's a good idea, once again, for property practitioners to understand their clients, how they came about that property. Under invoicing, now unfortunately under invoicing is where the property practitioner is actually involved in the money laundering themselves. So the seller would agree to a purchase price below the actual value and then accept the difference outside of the formal transaction, maybe in cash, so that it's not on the records. So we say we'll sell to you at 1 million, but in actual fact, the value is 2 million, and the other 1 million will be facilitated in cash, under the table, different means, so that the criminal can get rid of their illegal proceeds in a way that's not documented on paper. So it's more difficult to follow. So please watch out for these type of transactions. But sometimes there may be a legitimate reason for it, but it does raise a red flag that needs to be considered. Then, of course, all your property practitioners, the attorneys, attorneys who use trust accounts, you may come in contact with proceeds of crime. So if you are dealing with a client that you may identify as a criminal, means that you could have received illegitimate money, or you could have held illegitimate money for them in a trust account. And a lot of attorneys then want to rely on the attorney-client privilege, confidentiality, right, which is quite sacred in the legal profession. Please just note that the FIC Act actually overrides client attorney privilege. You cannot fall back on that if you know or you have a suspicion or you have identified a red flag on your client indicating that they may be a criminal. Right. And then the last two or three items on my slide just deals with some case studies from the FIC Center. One was with regards to a prominent influential person, which we will look at in a little bit more detail in a moment. But basically, individuals with a very prominent public position, such as a minister, a mayor, a president, member of the royal family. And these type of individuals are from the start higher risk, higher than your other clients, because of the fact that in the past they have been sometimes, not all the times, and I'm not saying all these people are criminals, but they have been linked to criminal activities and money laundering and bribery and things like that. So it's very important to perform enhanced KYC principles for your influential persons, prominent influential persons. In this instance, there was actually an investigation where the foreign prominent influential person was involved in embezzling. And they did that through purchasing property in South Africa, which at the end of the day was confiscated. The second case study dealt with an international drug trafficking, where the FIC was informed about a person who was known to be a kingpin in the international drug trafficking syndicate. And there was properties, of course, involved and so on. So at the end of the day, after the investigation, they confiscated 3 million worth of properties on this person's name. Now, once again, and that question always pops up, how do I know my client is a drug kingpin? Now, how do I know? You may not know, but there are certain steps that you can follow to try and find out. There are actual lists that are published with known criminals that you can use, and we will look at that later. And then the last one on my slide, just quickly, armed robberies. So there was a spate of armed robberies, and the FIC once again did a bit of investigation and digging with regarding the ownership of properties, directorships in companies, and it was found that some of the people involved in these armed robberies were directors of companies. They owned properties of high value, and once again, those were seized and forfeited to the state. They didn't specifically document what the outcome was with regards to the property professionals who helped in those transactions. But just reiterating once again, as long as you can prove you have followed the steps in the FIC Act, you cannot be found negligent. So there shouldn't be any negative implications then on you there. So with that bit of background and bit of statistics and examples, let's then look at what is these controls the Act provides us with. What are these steps that we need to perform to ensure that we deal with legit clients, that we do good business, and that we don't have criminals who are our clients. The section in the Act that we are referring to, if you want to go and read it later on, is section 20A to 21H. And the most important principles that these sections in the Act makes quite clear is that you can never ever have a business relationship with an anonymous or fictitious client. You don't want to sell a property to a client, register a property in a client's name, provide a bond to a client that you do not know who that person is. You either haven't seen the person yourself, or you haven't seen any identification documents, or you haven't received confirmation from other parties with regards to that person's identification. And that is then where your customer due diligence comes from, or KYC. There are 4 basic elements. Number 1, you need to know your client's identity. That's why we always ask for the ID. Please show me the ID. Please verify that you are who you are. What's important when it comes to the ID, though, is that you actually see the person together with their ID. It doesn't help that people just always deal over the phone and then they send you through a copy of their ID. Because how do you know the voice on the other side of the phone belongs to Piet Pompies? You don't know. He can say that's whom he is, but maybe he's stolen someone else's identity. So it's important to, first prize, of course, is always to see the actual ID card or ID book together with the person in person. And of course, if they have gone through great lengths to create a fake ID, that's not your problem. Right. There are, however, other options that you can follow. Verify with Home Affairs, and we'll give you that process later on to show you the how you can do that. Verify with Home Affairs the person's identity, maybe the photo that Home Affairs has on their system. You can also verify it with other accountable institutions, maybe other credit providers. Luckily, in a property transaction, as I have said, you have three role players. You have those who provide the bond, you have the estate agent, you have the attorney. So somewhere along the line, someone should have seen this client in person and can help the rest of the process along to say, yes, we've verified them. If you can't see them in person, well, the Act provides you, not the Act itself, the FIC Center provides you with guidance and alternatives. You may want to contact them over Skype. You may want to look at their digital footprint, go onto their Facebook, go on to Twitter, go on to Instagram. Actually, now with the internet, there's quite a lot of ways you can verify if a person actually does exist. So that's the first thing, determine the customer's identity. Know who you are dealing with. And together with that, if the customer or the person is acting on behalf of someone else, or someone else is acting on behalf of the client, you want to know the identity of both of these individuals, because they may be using nominees in order to conceal criminal intent. When it comes to companies, of course, there's a few more things you have to identify. You have to get certain information about that company. Usually we can follow that up with SIP-C, so that's very easy. The registration number, who the directors are, who the beneficial owners are. That's one of the items that can get quite difficult. That's my number 3 under my customer due diligence. The beneficial owner of a company, if your client is a legal entity. Because what if it is a company owned by another company, owned by a trust in a different country, owned by yet again another entity? Identifying a beneficial owner can become difficult. The more difficult it is to identify the beneficial owner, the higher your risk. Because why will someone go to such great lengths to hide the individual who controls these companies at the end of the day? Only thing I can think of is if they want to conceal some criminal activity. It's not always the case, but please just take note that that does increase your risk. You also want to understand the nature of the business relationship. Why does this person want to enter into this transaction? Now, for property transactions, that's easy. Either I want to purchase a home to actually stay in, or a property to rent out, or investment property to sell again in future. So at least the transaction itself isn't necessarily suspicious. However, part of that, you want to identify the source of funds. Where does your client get the money to buy this property? Is it a bond? Is it a salary? Is it a business? If it's a business, a company, then of course you want to know, what does this company do? What do their financial statements look like? Do they actually have the money to purchase this property? And then our fourth element is to conduct ongoing due diligence. Ongoing due diligence means to, now that I have a relationship with this client, and this is more for ongoing transactions, not just a once-off. So if you just have a once-off, a family comes, they purchase a home and they leave, then that's it. If, however, you have a relationship with a client where you do monthly rentals for them as an estate agent, or as an attorney, it's a company and maybe you are that company's attorney, so you do different transactions for them and different work for them. You want to do ongoing due diligence. That means to just literally keep an eye on your client, to identify actions outside of the ordinary, where suddenly a company that you have been dealing with for years suddenly buys a property that's totally outside of their means. Or a client that you've been dealing with for years in terms of rentals, maybe, suddenly acts in a way that is contrary to how you would expect them to act. And then that would raise a red flag, and you will then follow up on that. So these customer due diligence, these steps that we perform, is to pick up on red flags, right? To identify risk that a client may be committing fraud or money laundering or anything illegal that I may need to report. If you perform these steps correctly and you identify no red flags, nothing pops up, well, then that you've done what you could have done reasonably. If, however, a red flag pops up and you don't do anything, you will be in trouble. You were negligent. Now, when the Act changed in 2017, they changed the way that we do the customer due diligence. Before 2017, it was a tick list. So there was a whole list of you need to get the ID, you need to get the proof of residence, you need to get the tax number, right? You need to gotten all of these things from a client, quite a lot of things, to show that you have identified who this person is. 2017 came and our act was changed to a risk-based approach. So from 2017, they said you have to identify the risk that a client may commit fraud in this transaction. And then based on that, maybe you'll do a little bit more procedures to identify red flags, or you can do a little bit less. Now, I think we can all agree that conveyancing, based on what we've seen up until now, in and of itself is quite a high risk, right? The type of conveyancing transactions we have. So we already know the transaction itself is high risk. Well, the other side of it is your client. Is your client high risk? And the more high risk your client is, the more procedures you will have to do to verify this person to ensure that there are no red flags. When can a client cause a higher risk? The Act provides several instances when that individual is a prominent, influential person. So we said someone with a prominent public position, a minister, a president, a person of the royal family. There's actually a list in the Act. I'm not going to go through that whole list now, but a public official, someone in the public sphere. That will cause the client to have a higher risk. Then we also have lists that are actually released by the United Nations Security Council on a regular basis of people identified to be part of terrorist groups, criminal groups, people who have been either convicted or found to be guilty of certain crimes. So you can screen your clients against those lists and say, okay, they're not on this list, so great, not a high risk client. Geographically, it can also cause an issue. We have certain countries with significant deficiencies where their money laundering legislation is not up to the standard it should be globally. So the two specifically at this stage with significant deficiencies is your DPRK, right? The Democratic Republic of Korea, yes, and then Iran. At this stage, those are the two countries with the highest deficiencies. But there's also other countries with lesser deficiencies that include countries like Cambodia and Botswana. And it's important that we know about this, that we are aware of it, so that if our clients come from any of those countries, we need to raise the risk on that client a little bit. So at the end of the day, what I'm trying to say here is not only do you need to identify your client, you also need to screen your clients against these lists and say, are my clients included in any of these lists in terms of being a public official, a person who has been convicted or who has been identified as part of a terrorist group, or are they from a country with a significant deficiency? So that at the end of the day, you can document your risk properly and implement controls to cover your risk. So let's look at this risk-based approach. What do we take into account when we identify the risk for each and every client? The guidance from the FIC Center talks about the specific product or service, and we already said conveyancing sometimes is a high risk. I guess it would depend on the type of property, the value of the property, the reason why this person is purchasing it. I mean, if a nice family came to you, mom, dad, 2 kids, we want to purchase a house because we need to move into it, our current house is too small, then maybe we can say the risk is low. So what are the type of product here? The delivery channels. How do you deal with your client? Is it a direct relationship? Have you met the client? Or are you working through an intermediary, nominees? Is it face-to-face or non-face-to-face? That can actually impact the risk. The location, we already talked about the jurisdiction with high risks. So where is this client from? That can impact the risk. What's the client type? A legal person where you cannot identify the beneficiary owners may pose a higher risk than a natural person. A company who has a complex structure, a complex group structure, may pose a higher risk. The politically exposed individuals, we already said, they pose a higher risk. Someone with adverse or negative media against them may pose a higher risk. And then there are other factors that you can consider, such as your own money laundering approach. Maybe you have written things into your approach to say these specific characteristics may increase or decrease a risk. And then all of this together can be used to identify the risk per individual client so that you can identify how much work you need to do for that client. So just to give you an example of what that may look like, client type, if it's a natural person, level of 1. But property purchase, of course, may be a little bit higher, level 6, where a rental may be a lower risk. The jurisdiction you can allocate. So it depends on how you want to do the risk assessment yourself. We are going to look at the example of the LexisNexis product as well and how it's done. But then based on each risk ascribed to each characteristic, you can then identify what the final rating of risk is for this client. And based on that final rating, you then either have to do more KYC or less. So if the risk is low, well, then really it's only important to get the client's ID and their source of funds and say, okay, this is why you purchase. Happy, let's go on with it. If the risk is higher, maybe you want to dig a little bit more, know a little bit more about this client, know a little bit more about this company, about this entity, to ensure that you're not dealing with a criminal. And at the end of the day, if you can prove that you've done a proper risk assessment, which is, as I said, just good business because we don't want to deal with criminals, and as per the risk, you have implemented certain controls and no red flags was identified, then you are on the right side of the law and you shouldn't have any problems. Right, I've gone a little bit over my time, 3 minutes, so that's where I will stop. Thank you, ladies and gentlemen. And then I am giving over to Richard. I'll just stop sharing my screen now.
So just before we move on, there's a couple of questions, Yvonne, so we can maybe just answer some of those questions. You talked a lot about the fines, imprisonment, and 100 million rand guilty of it. Could you take us through the training requirements that's necessary to be compliant?
Right, so for all your employees that specifically deal with the public, as I said, with clients who will have to sign a contract with a client, who will have to help a client to get a bond or to register the property, they all need to have training on, number one, the requirements of the Act. So the fact that we need to do customer due diligence, we need to get certain information on the clients, and then very important, what to do if you do identify red flags. follow it up and report back to the FIC Center, of course, if a suspicious transaction was identified. What is important, though, about this training that you provide to your employees is that it should be specifically tailored to your type of profession. The thing that the FIC Center has found with training, what happens quite a lot, is people will attend a generic FICA training, and the session will provide them the requirements in terms of the act, but it will not focus on that specific profession or that specific entity's risk of being used for money laundering. So individuals are aware of the act, they know more or less what the requirements are, but they have no clue how to identify a suspicious transaction for their specific industry. So it's very important that when you do training, you ensure that it is tailored for your industry.
Thank you. And then I've got another question here. It is a professional mediator. So a person's doing divorce and commercial mediator. And should these individuals also be conducting FICA on their customers?
Yes, unfortunately, all legal practitioners who have a trust account. So please just take note, the second schedule talks about legal practitioners running a trust account. Previously, that could only have been attorneys, but since we have the Legal Practice Act now, the attorneys and the advocates can do that. So if you have a trust account, you're running a trust account, you're taking money on behalf of your client and putting it in a trust account, then yes. If you don't have a trust account, the answer is no. Then you actually don't have to perform all of these steps. That being said, you still have to comply with FICA because all companies need to comply with it, in that if you identify a suspicious transaction, you need to report it. So the reporting requirement is still there, but all the other registration with the FIC Center and KYC and all of that is not necessary if you're not using a trust account. So basically, you don't need a Fidelity Fund from a Fidelity Fund certificate from the Fidelity Fund. If you do run a trust account, but you only provide services such as prenuptial contracts, divorces, those type of things, it can be that your risk assessment for your type of product and your clients may be quite low. Because to be honest, if you get a client coming to you saying, I would like to do a prenuptial, how are they going to commit money laundering through that, right? Unless they pay you with money that they have stolen or with illegal funds. So it's quite difficult to launder money through a prenuptial contract or a divorce settlement. That being said, I understand that criminals also do get divorced, right? And criminals also do sometimes need a divorce attorney to split things up. So just watch out when you are dealing with clients, especially in a divorce, and there's huge settlements and large assets involved. You want to make sure that you are not dealing with criminals. So then you want to maybe do proper KYC to verify that your clients and their funds and the assets that are being split in this divorce is legitimate.
Thank you. I've got another interesting question here. Do auction companies that are agents which sells property and cars on behalf of banks follow the same route?
They sell property and cars on behalf of the banks.
Yes.
Are they only that's a difficult one. They would have to identify if they're only acting as an agent for the bank, or if they are doing that themselves. If they're only acting as an agent for the bank, it may be, and I say may, it really does depend on the specific situation. It may be that they are not an accountable institution, right? That the bank in this instance would have to be the accountable institution and follow all the rules. If they're just an agent or part of the bank, but if they are a totally separate company doing those transactions, even if it is on behalf of the bank, then they would have to be registered. The motor vehicles at this stage is only a reportable institution, so they don't have to follow all the steps. However, that is going to change in future. They're bringing in changes that motor vehicle dealers and people dealing in motor vehicles, auctioneers and so on, will actually have to perform all the same steps as the other accountable institutions. So yeah, I would have to get a bit more information on that question before I can give a proper answer.
I agree with that. Thank you for that. Then the last question I'm going to ask before we move on. Can FICA documents be in the cloud?
Sorry, I missed that question.
Can FICA documents be kept in the cloud? So storing your documents online and not in physical form?
Yes, yes. So it can be kept hard copy, it can be kept soft copy, cloud, it can be kept by third party. As long as you know where it is, you have access to it, and you protect it under POPI. Please remember, because FICA documents are quite personal information, looking at IDs and things like that. So definitely.
Thank you, Yvonne. We appreciate it. Yeah, that's quite important. That's POPI is also coming into effect on the 5th of July, so it's around the corner for us to all get in line with that. And Yvonne can also help you on that as well. So at this point in time, we need to move over to Richard to take us through Lexis KYC.
Thank you, Rudy. I won't take too much of your time. I know everybody's busy and we're running out of time a little bit here. So good morning, everybody. My name is Richard Randall, and I am the product owner of Lexis KYC, an exciting addition to the LexisNexis product portfolio. And we're hoping that KYC helps you with your KYC needs. So let's get my PowerPoint presentation working. So how does Lexis KYC support you to become more compliant under the FICA Act? Well, we support the core pillars of FICA compliancy. So by working with firms to implement a risk-based compliance program, allowing a compliance officer to adjust the risk appetite that suits your needs and control that risk per entity being investigated, seamlessly identify customers using photo ID, home affairs details, verify address details, and the contact details. And of course, allowing auditing of the interaction with the system, record all the verifications, the outcomes, and store the documents required as per the FICA process. And lastly, of course, to allow full screening against the various watch lists, as was mentioned by Yvonne, for terrorism, sanctions, adverse media, and political exposure. So how does it start? Let's have a quick look at Lexis KYC. So a unique risk-based assessment is set up for each firm, taking into account your individual risk appetite, allowing weightings to be applied to categories that affect you most, such as direct customer risk, possible different product risks, or a business activity that your transactions may be covering. This allows a standardized assessment to be created with questions tailored for your firm. These risk questions, each question can be crafted with various inputs, such as this particular question here. Question number 2, as you can see, is the customer married? The question type is a drop-down, so there'll be answer types that can be selected from a list. The answers are yes and no, and follow-up questions can be created, such as, for example, here, if you answered yes to is the customer married, is there an anti-nuptial contract in place, yes or no, and again, risk can be assigned to each of these answers. Once completed, the risk assessment is shown during the onboarding of the customer and the questions posed during the onboarding process. These drive both the risk that can be uncovered by the answers, as well as the background checks that the system will do for you. Once you've completed the onboarding, the answering of the questions, and the searches have done, a profile is created within the system, and this is automatically created to group together all the various verifications undertaken by the system and indicates a possible risk that the entity may pose. You can easily see where issues lie here by looking at the summary screen. And in this particular instance here, we've blurred out some of the detail, obviously for privacy, but a photo is returned from the Department of Home Affairs, so you can check that the person you're interacting with is the correct person. You can see that they're alive, they're not deceased, and some other details that pertain to this particular individual, such as the address, contact, and if any due diligence searches were done, they would show down here. So let's drill down a little bit quickly. So we're looking at the contact information tab here. Here is the address that was provided by the customer and some of the addresses that were returned from the bureaus. The system will automatically try to match those systematically by showing you a green tick. If not, a red cross is shown where a match cannot be found. Due diligence screening is done by our World Compliance Service. So what we do during the screening, which we screen against, as I mentioned, sanctions, terrorist, political exposure, and adverse media, we attempt to match the customer that you're onboarding with people on the various lists that may match. So in this particular instance, we've tried to match LexisNexis risk management to the LexisNexis full compliance database, and you can see a list of matches have come back. A match score, if I drill down into the first one here, is shown here at the top, 92, which gives you a determination of how accurate the match could be, as well as where the results are coming from. So in this particular instance here, the alert type is some sort of enforcement for discipline. The match is 92, so we consider that to be a fairly good match. You can expand the details over here, and obviously a summary of the various results is shown, and that will show you the articles and judgments that were found, and you can drill down into the particular news article if you wanted to. Additionally, the system requires you to mark the result as being your customer or not at the top here, and just allows auditing of the system to make sure that you actually did view the data and you made a call on it. Finally, you can make notes against these particular profiles as well if you wanted to make some sort of notes that would be saved within the system. Moving on to our risk assessment. So the risk assessment tab, obviously, it tries to assess the risk the customer may pose. So in this particular instance here, you can see all the questions that have answered during the assessment are shown, as well as the answers given and the risk that was applied to those. The weightings then for each category are applied, and an overall risk of the profile is then shown at the top here. This will allow you to determine if the risk of the customer, or determine the risk of the customer that may pose to you in terms of your compliance program. Overriding these risks can be done by the compliance officer, but of course that would be audited by the system. Talking about auditing, all interaction with the system is saved within the history. So a history shows a full audit of interactions, as I mentioned, including who, when, and what was done on the system, as well as gives a running timeline of the interactions. So this means if you onboarded a customer who initially was unmarried, and later on during a re-identification process, you can see that they are married, we would obviously keep a running timeline of that customer, and you can see how they change over time. Finally, document storage. So there are documents, unfortunately, that need to be stored as part of the FICA Act, and these can all be stored within the system in the document store. These are safely and securely stored by LexisNexis, but of course, hard copies can be created by the system if you so wish, and they can be printed out. So that was short and sweet, but as you can see from this quick overview, Lexis KYC can make your FICA compliance a little bit easier by providing a single point of verification, risk assessment, document storage, and the ability for auditing to be done in one place, and all the information can be printed, as I mentioned, in hard copy. Thank you for allowing me to show you our exciting new products, and handing you back to Rudy.
Thank you, Richard. Appreciate it. Yeah, so ProBeta, Yvonne's company, informed us that they will give a 50% discount on all FICA training to all the attendees. So please use this opportunity. And then there's a poll. If we can ask everyone to complete that for us, it will really help us to understand what we need to do and how we can improve this. I've been in the AML and FICA for many years, and I've learned a lot today. So there's always opportunity to learn a bit more. You never know everything. Yeah, so thank you everyone for attending today, and let's all help LexisNexis advance the rule of law and implement the process and the learnings you got from today to make sure we protect our financial services and our financial system. We're going to remain open as people still completing the polls for now. Thank you.